Hi everyone, welcome back to The Whole Truth. I'm Gillard Bell, and I want to discuss the past few days of the preliminary hearing of Tyler Robinson. I want to preface this by saying, as a criminal defense attorney, I do have experience on the prosecution side, but I can't help but look at it as a criminal defense lawyer. And also to let everyone know that I practice in California. There are differences between California and Utah, but usually most of those differences are pretty insignificant. So, big takeaways from what I've seen the past few days. The prosecution has a very strong case here. I mean, we're everyone should keep in mind we're at the preliminary hearing stage. That means the prosecution is just trying to establish probable cause, which basically means a reasonable person can conclude that the person being charged, the defendant, in this case Tyler Robinson, did in fact commit the crime. Could a reasonable person believe that? I think it's pretty obvious that the answer is yes. Once we get to the jury trial, then the standard becomes much higher for the prosecution. They have to prove that he did in fact commit the crime beyond a reasonable doubt. So we are going to see more both from the defense and the prosecution during a jury trial. But from my experience doing preliminary hearings, this has been, the evidence has been overwhelming. So to begin with, we have surveillance footage of Tyler Robinson at the scene, at the campus. I think both before the incident and before the day of the incident and on the day of the incident. What I find very significant about this is that he was not a student there, and he did not live down the street. So why was he there? That's something that the defense is going to have to contend with. Not only that, but apparently he had some food there. That's probably going to be showing up on a credit card transaction. In addition to the surveillance footage showing him there, as he was identified by his roommate and his vehicle being there. The clothing that he was wearing was familiar to his roommate. So I don't think that the defense is going to argue that he wasn't there. The next item of evidence, his DNA. His DNA was found on the screwdriver that was left right next to the position of the shooter. And if you recall, the investigating officer said they located, moved gravel where the shooter was, and they saw a screwdriver there, which would make sense because the gun that was used needed a screwdriver to be taken apart. So Tyler's DNA was found on that. And Lance's, Tyler's roommate. How do you explain that as a defense lawyer? Next, Tyler's DNA was found on the towel that was wrapped around the gun that was used. That towel and the gun were found, I think, right next to each other or together. And again, I have not watched every second of the preliminary hearing. I have 2 daughters and a full-time job. I tried to keep up with it as much as possible, but I certainly have not watched every detail. But again, Tyler and Lance's DNA were found on the murder weapon. Speaking of the murder weapon, the ballistics report came out today, which is related to the autopsy because the fragments of the bullet that was recovered from during the autopsy they did say that it was inconclusive. It cannot be conclusively determined that those bullets came from the found gun. However, it is consistent with it. So that doesn't mean that it did not come from it. It just means that there was no conclusory proof of it, which is something the defense, as you probably saw, is jumping on. But that's not really a strong defense, in my opinion, because all that would mean is that, again, that the bullets that were recovered were too damaged to be proven to have come from that particular weapon. As for the weapon belonged to Tyler Robinson's grandfather. That can come out in any number of ways. Of course, Tyler Robinson's grandfather himself could say it, Tyler Robinson's parents. But to me, the most damaging piece of evidence, and I think this came out today, were the text messages. It could have been yesterday. But those text messages, which were recovered from Lance's phone, and again, to remind everybody, Lance Twiggs is Tyler's roommate slash lover, are probably the most damning. They conclusively show that from Tyler Robinson's phone, there are multiple text messages that show that he was the one that committed the crime. He admits to it. He provides evidence that really only the shooter would have known about. He talks about, retrieving the gun from the particular location. And I don't think we've seen the cell phone tower data, but that's going to be just another straw to break the camel's back, so to speak, because those cell phone towers have a radius of, I think, not very large radius. I don't know how large off the top of my head, but you can basically pinpoint where someone is very close to their actual location. So that's going to come out. Then you have Lance Twiggs' testimony. And this would not be allowed during a jury trial for somebody to provide testimony like this outside of a courtroom. But because this is just a probable cause determination, that is allowed in Utah. Any evidence that's hearsay, if it's considered reliable, it's allowed during the preliminary hearing. Now, during trial, they're going to have to actually have Lance Twiggs in the court to testify. And that will give the defense an opportunity to cross-examine. So coming at it, and there's more on top of all of this. Again, there's the autopsy report. There was DNA that was, there was the Dremel tool marks because the bullets had engravings. There was the Discord chats. There was the fact that he surrendered himself. I mean, that's not something that you get with most cases. So, and then there is the ring camera footage also. So the evidence is overwhelming. What am I thinking as a defense lawyer? If I'm defending Tyler Robinson, and keep in mind, everybody, because I know a lot of people have this, distaste for Tyler Robinson's lawyers. Their job is to defend him. If you don't want to do that, you shouldn't be a defense lawyer. Even guilty people have the right to a zealous advocate. And there's a lot of different reasons for it, but the main reason I tell people is that we want prosecutors and investigators to do their job right. We don't want them to half-ass it. And without a strong defense, then prosecutors and investigators are not going to work extra hard to maintain the integrity of evidence and the investigation. And so I don't think anybody should have any ill will towards Tyler Robinson's defense. So anyways, as I was saying, as a defense lawyer, what am I trying to do? Well, outside of the jury trial, I'm trying to get as much of this evidence disqualified and excluded as possible. There's a number of grounds that you can argue. You can argue on relevancy grounds, that the probative value, meaning the how much information you get from the evidence, is outweighed by how prejudicial the evidence is. You can argue, or that it's unnecessary. It's just, that would not really apply to any of the evidence we've seen because it's all irrelevant and not very prejudicial. Or at least not weighed by prejudice. You can argue that, again, lack of authenticity or lack of foundation. That would be something that you would argue about maybe surveillance camera. If you can find some gaps in the chain of custody of the surveillance footage, then you might be able to get some of it thrown out because you don't know if it's been tampered with. You don't know if the footage that you're seeing now was the footage that was actually gathered, or at least a recreation with good integrity. If they didn't transfer the data using the best methods, that might be something you would argue. When it comes to actual witness testimony, you would be making objections more than asking for, I mean, you could make a written objection ahead of time asking that certain topics not be discussed. And again, all the same grounds. Lack of knowledge is another one. If the person is being asked questions about where they don't know, it's just kind of a speculation, that's grounds for an objection. So that would be all the things that you're doing outside of the court, not outside of the courtroom, but outside of the trial, outside of the presence of the jury. Now, from what I'm seeing, that's not going to be very successful, at least for most of the evidence. And even if they are successful with a lot of the evidence, by them I mean the defense, it's not going to be enough. I mean, there's still going to be a lot of evidence. And again, at jury trial, we are going to see a ton more evidence. And not only are we going to see more evidence from the prosecution, maybe some from the defense, but they're also going to have an opening statement that really lays out the evidence in a nice little way. And then their closing argument is really going to tie a little bow on it. So right now we might be seeing kind of sporadic pieces. We're seeing surveillance footage, and sometimes we're seeing surveillance footage at other times, and maybe it's hard to keep track of the exact timeline of everything. But during a jury trial, when you're presenting it to a jury, you have to make things very clear. So going back again to what I'm doing as a defense, I want to attack the credibility of all the witnesses. When it comes to the law enforcement officers, you try to find something that would make them biased. I saw that a little bit. The defense was trying to show that they maybe got into this tunnel vision, and I've seen it happen where once law enforcement kind of gets a lock on a suspect, they start ignoring other potential leads and other avenues. Again, I'm not saying that I think that this is going to be successful. Your job is to try. You're going to attack the credibility of Lance Twiggs. Again, he might have bias. You could see if that he has some animosity towards Tyler. I didn't see any of that evidence of that come out. I don't think that that's the case, but who knows? Maybe he has a criminal past. You are allowed to use prior instances if certain types of felony convictions can reflect badly on someone's character. You can use that. But really, as a defense lawyer, my strategy would be, again, once we get to the trial phase, after all the evidence is approved, I did see a little bit of, the defense trying to say some sloppy police work, try and throw as much sand out into the eyes of the jury, and hoping that you got one kind of one juror that might not be perfectly convinced that Tyler Robinson did it. So anyways, that's my take. I'm gonna try and if you haven't already, please subscribe to Paramount Tactical. Please also subscribe to my channel. He's been having me on as a guest, and I'm going to keep trying to follow this case as closely as possible and providing these video updates. Thank you.